How do you probate an estate in California? Hi, I'm Daniel Hunt. I'm an attorney that practices in trust estates here in Sacramento, California. And in previous videos, we've talked to you about how to avoid probate by using a trust or gifting everything away or in joint tenancy. But today, we're going to talk about how you actually would go through a probate if you fall into the category that it must be done when you pass away. So first, who will handle the probate? That's going to be the administrator or executor. That person will go and file a petition in court to be appointed as the executor if there's a will and they've been named in it to administer the estate. Or if there's no will, they're going to file as the administrator to petition the court and say, I want to administer this decedent's estate. So because the probate process in California can be very long, exhausting, overwhelming to a lay person, many times the administrator or executor will seek the advice of an experienced probate attorney to help them through this process. So what are the basic steps of a probate in California? First, as mentioned before, a petition is filed to appoint an administrator or an executor. Once the petition is approved, letters are issued from the court. The letters are the legal authority given by the judge to the administrator or executor so that they can go and do their job. Start collecting assets, speaking with who they need to speak with, banks, creditors, in order to get the estate administered. After the letters have been issued, and once all of the estate assets have been collected, an inventory and appraisal has to be filed by the executor or administrator, which details all of the assets of the estate. When you have all the assets of the estate gathered up, you have to make sure that all the creditors have been paid or dealt with. That's the administrator or executor's job to figure out whether they should be paid, whether things might be compromised, paid in part, but that's their job to make sure that all the creditors are satisfied. Once all the creditors have been satisfied, all the assets have been gathered, all the taxes have been paid, now the estate is in a position to be distributed. A petition is once again filed in the probate court that says, Judge, we've paid off the creditors, we've collected all of the assets, and it's in a position to be distributed out to the beneficiaries. Once that petition is approved, then the administrator or executor can distribute the assets to the beneficiaries of the estate, and everybody is hopefully happy now that the estate has been administered. So how long does this process take? The quickest that you can typically get through a probate in California is about 9 to 10 months. But generally speaking, most probates take closer to 18 months to finish here in California. How much does probate cost? Well, that's set by statute. You have filing fees of $435 in order to open up the probate. But the biggest costs are the cost to pay the administrator and the attorney that typically will help the administrator or executor. And that is once again set by statute. It's in the laws. It's 4% on the first $100,000 of the estate, 3% on the next $100,000 of the estate, 2% on the next $800,000 of the estate, and 1% on the next $9 million of the estate. So you figure that out, and it ends up being expensive. That's the long and short of it. So you want to generally, as we've explained in other videos, try to avoid probate because it is so long and so expensive. So there you have it. That's the general steps of how to accomplish a probate in California, the time, the cost. And if you have any questions, you can always contact our office at dhtrustlaw.com or at our phone number 916-488-9788. Thanks. We hope you found this video helpful, and if you'd like more information on estate planning or our law firm, you can check us out on Facebook, Twitter, or our website that are listed below. If you'd like to contact us, you can do so at 916-488-9788 or at our email info@dhtrustlaw.com. Thanks.